Hello and welcome. If you have any sort of connection to Canada, maybe you live here, work here, or own property here, there is one question that is absolutely fundamental for tax purposes. Are you a resident? Now, it sounds like a simple question, right? But the answer determines whether Canada gets to tax your income from all around the world. And getting it wrong can have some pretty serious financial consequences. So today, we're going to break down exactly how it all works. Oh, there's so many yummy vegetarian options out there. You could try like lentil soup, veggie burgers, tofu stir-fry. The possibilities are endless. So let's just dive right into the core question. Are you a resident of Canada for tax purposes? And I want to be really clear about something right off the bat. This has nothing to do with your passport or your citizenship. For the Canadian tax system, it's all about one thing. Does the government consider Canada your home? Answering that question is what decides whether you pay Canadian tax on your income, no matter where in the world you earn it. And why is this so important? Well, to put it plainly, the stakes are incredibly high. The decision about your residency can completely change your final tax bill. So it's not just about knowing the rules, it's about understanding how they apply to your specific situation, because it really matters. So how does the Canada Revenue Agency, you'll often hear it called the CRA, actually make this decision? Well, it's not arbitrary, and it's not a guess. They follow a very well-defined framework that's been built up over years of court cases and their own internal policies. So let's unpack that process together. First, things first, we have to understand the core concept itself. You see, unlike the United States, which primarily taxes based on citizenship, Canada taxes individuals based on residency. This is a fundamental difference you have to grasp. If you are a resident of Canada, your worldwide income, every penny, is on the table for Canadian tax. Now, for most people who live and work entirely within Canada, this is, frankly, a non-issue. Their residency is obvious. But in today's world, so many of us have international ties, a job in another country, family abroad, property overseas. For those individuals, this question of residency suddenly becomes incredibly complex and absolutely critical to get right. And this brings us to the main framework the CRA uses. It's called factual residency. Now, this isn't some simple checklist you can just tick off. No, it's a careful, detailed examination of all the facts of your life to figure out where your true center of gravity is. And they do this by analyzing what they call residential ties. So what do we really mean by factual residency? Well, in simple terms, it's a conclusion based on all the evidence that an individual's life is fundamentally centered in Canada. The question the courts often ask is, in the settled routine of your life, is Canada your home? It's a matter of fact, not just about what you declare or where you'd prefer to be a resident. Now, here's a crucial point. The CRA doesn't treat all facts equally. They actually organize them into a hierarchy. You have what are called primary ties, which carry the most weight in the decision, and then you have secondary ties. Think of these as supporting factors that help paint a fuller picture, especially when the case isn't so clear-cut. So let's look at those primary ties because these are the heavy hitters. There are 3 of them. First, having a dwelling place in Canada that's available for you to use. Second, having a spouse or a common law partner who lives in Canada. And third, having dependents like your minor children who remain in Canada. And get this, maintaining even just one of these ties can be enough for the CRA to consider you a resident. Let's make this real with an example. Imagine Maria. She's an engineer who takes a 2-year contract in France. Sounds like she's left, right? But her husband and their children stay behind in their family home in Toronto. So despite her being physically in France, her most significant ties, her spouse, her dependents, and her home, are still firmly planted in Canada. In a case like this, the CRA would almost certainly continue to view her as a factual resident. Okay, now let's talk about those secondary ties. These are all the other little things that add detail and context to the picture of your life. The list is pretty broad. It includes personal property you keep in Canada, like furniture or a car. It includes social ties, like memberships in clubs or associations. It also covers economic ties, like Canadian bank accounts, and even administrative links, like your provincial driver's license or health card. On their own, they usually won't make you a resident, but when you put them all together, they can strongly support the conclusion from the primary ties. All right, so the factual residency framework covers most people. But of course, in tax law, there are always special rules for unique situations. This brings us to the concepts of deemed and part-year residents. Let's see how these rules build on what we've just learned. So one of the most important special rules comes down to a single number, 183. This number is a critical line in the sand. If you are physically present in Canada for 183 days or more in a single calendar year, the law can deem you to be a resident for that entire year, even if you don't have any of those significant residential ties we just talked about. And there's a specific legal term for someone who gets caught by this rule. They're called a sojourner. This is a person who is just temporarily in Canada. Maybe they're here for an extended vacation or a short-term work project, but their stay crosses that 183-day threshold. The key thing to remember is that they aren't a factual resident. Their real home is somewhere else. But their physical presence alone is enough to trigger this special rule. Let's look at Frank. He's a U.S. citizen and resident, and he loves his summer cottage up in cottage country. He comes up in April, and he leaves in late October, spending about 7 months here. That's well over 210 days. Now, even though his home, his family, and his entire economic life are clearly in the U.S., just by being physically present in Canada for that long, he becomes a deemed resident for that entire tax year. Another special case to know is part-year residency. This one is really for immigrants and emigrants. Let's say you sever all your residential ties and officially leave Canada on May 27th. For that tax year, you're considered a resident from January 1st to May 26th, and then a non-resident for the rest of the year. Your tax obligations are essentially split right down the middle. All right, so what happens when things get really complicated? What if the rules of two different countries both claim you as a resident at the same time? This is actually a common problem in international tax, and thankfully, there's a specific way to solve it: international tax treaties. I mean, think about it. This is a critical question. If you are a factual resident of Canada, but you also meet the residency test for, say, the United Kingdom, you could be facing the nightmare of double taxation, where both countries want to tax you on your worldwide income. That's where these treaties become absolutely essential. The solution is a special set of provisions that are built right into these bilateral tax treaties. They're known as tiebreaker rules, and they are designed for one very specific purpose: to look at the situation and assign residency to only one of the two countries, which resolves the conflict and makes sure you're not taxed twice. Now, these rules have to be applied in a very strict sequential order. You can't just pick and choose. First, you look at where you have a permanent home available. If you have one in both countries or neither, you move to the second test, your center of vital interests. This is where your personal and economic ties are stronger. If that's still a tie, you look at your habitual abode, where you spend more time. If that doesn't solve it, you look at citizenship. And if all else fails, the tax authorities of the two countries will actually get together and decide the matter for you. Okay, so we've covered factual residency, we've looked at deemed residency, and we've unpacked the treaty tiebreaker rules. Now let's put it all together into a clear, coherent framework that you can actually use to analyze any situation. Here it is, the general analysis in 5 clear steps. This is the exact logical process a tax professional would follow. Step 1. Apply the Canadian rules to see if you're a factual or deemed resident here. Step 2. Apply the other country's rules. If you're a resident of both, move to Step 3 and check for a tax treaty. If there is one, you move to Step 4 and apply those tiebreaker rules we just discussed. And the final result, Step 5, will deem you a resident of only one of those countries for the purposes of the treaty. So we've unpacked the rules, the logic, and the framework behind Canadian tax residency. You now have the tools to analyze this. So the final question I want to leave you with is a personal one. When you weigh all the factors we've discussed today, your home, your family, your economic life, where is your true center of vital interests? Because for Canadian tax purposes, the answer to that question, well, it's everything.